We are going to start with arguments in the case of State of Ohio versus Tony Taylor. That's case number 29230. Both parties are represented by counsel, so each of you will have 15 minutes to present your arguments to the court. The appellant may reserve up to 5 minutes for a rebuttal. Let me know if you're going to reserve rebuttal time, and I'll try to remind you as you get close. Also, we have the running clock on the wall there. The arguments are recorded and videotaped for presentation on the court's YouTube channel, so we ask that you stay at the podium and keep your voice up. Any victims or children we refer to by initials, since we do record and replay the arguments. Having said all that, I will indicate we've read the briefs and are ready to proceed when you are. Attorney Stiles.
May it please the court, counsel. My name is John Stiles. I am standing in for Attorney Noah Winer with the client's consent. We represent Mr. Taylor on this appeal. It took 1 minute and 48 seconds from the time the Officer Ross confronted Mr. Taylor to the time he was arrested in this case. During that time, Mr. Taylor had lost possession of his property and went to retrieve it. He was in a restricted area for no more than 20 seconds before being yelled at by an officer, being confronted, and ultimately arrested. He was convicted of App.No Ordinance 13201A1. No person shall recklessly cause inconvenience, annoyance, or alarm by engaging in fighting, threatening harm, or by violent or turbulent behavior. I think each and every one of the words in that statute are going to be very important in our appeal today. We raised 3 issues with this conviction: sufficiency of the evidence, manifest weight of the evidence, as well as a violation of his constitutional right to free speech. As an initial matter, the Appellate State of Ohio has argued in their brief that the manifest weight issue should not be heard today because it was not separately assigned as an error. They rely on 2 cases for that proposition: Hull v. Silver and State v. Muka. In those, both courts in those cases declined to hear a particular issue because they were disregarded and not assigned separately. However, in those cases, it was stated that the court is actually not compelled to decline that if it's not separately stated as an issue or as an assignment of error. And the reasons that they declined to hear that or to consider those arguments were because there were some technical issues and no separate headings, not citing to the record, as well as some substantive issues, as well as not providing any challenges, citations, things of that nature. The appellant does state that in our brief we have laid out separate areas of law for both assignments of error, both issues I should say, as well as argued that both separately making proper citations to the case. So we would respectfully request that both of those be heard. Moving to the first issue, the sufficiency of the evidence, this tests whether the state has really met its burden of production and evidence. After viewing all the evidence in light most favorable to the state, could a rational trier of fact find the essential elements beyond reasonable doubt? Again, I think that the words of the statute here are very specific and very important for today's appeal because the words in there require a causation of inconvenience, annoyance, or alarm through fighting, threat to harm, or through violent and turbulent behavior. In this case, it is undisputed that Mr. Taylor did not engage in a fight with this officer. He also did not make any threats to self or property of Mr. Officer Ross.
Did he make contact with the officer when he rushed by him?
He did not. The officer actually initiated contact with the appellant in this case. And I think that's important to mention because at that time, prior to the contact with the appellant, Officer Ross had never made a statement to Mr. Taylor to stop or to cease where he was at. So at that point, Very few words had been said. Mr. Taylor was not told to stop. He was not being told he was being investigated in any way. And at that time, as he was leaving that restricted area, he was pushed into a railing by the officer. So it is undisputed that he did not engage in fighting, did not threaten the officer at that time. It's also undisputed that Officer Ross was assigned to patrol that area. He had taken on certain duties that came with that assignment to basically keep safe that restricted area. On page 39 of the transcript, Officer Ross admitted that people frequently enter those areas because they're not well marked, and that it is very easy for somebody to slip past some of those marks.
Of course, Mr. Taylor ducked under not a wire, but some sort of a restricted notice, rope or something.
Yeah, the tape, there was a piece of yellow tape there. I don't think that it was clearly marked whether that, I know that it was not a police marked tape, so I don't know if there were any words on that tape or not that really indicated that that was a restricted area for a particular purpose. But he did cross into that area. Again, he was there for a brief period of time, maybe 10, 15 seconds to obtain his own property, which he did inform the officer of at that time. Again, going back to the words of the statute here, inconvenience and annoyance really stand out at this time, I think. At that time, once he had crossed over that tape, Officer Ross basically had to engage the duties that he had taken on at that time. To say that he had caused an inconvenience or an annoyance at that time because Officer Ross had to do his duties, I think would be akin to saying that we've created an inconvenience or an annoyance to this court by filing this appeal. We've taken on certain duties in our professions, and when we're in a position where we have to fulfill those duties, I don't think we can consider those an annoyance or an inconvenience. Also on page 37 of the transcript, he testified that in 32 years he's come to understand his job comes with a certain level of inconvenience and annoyance. He understands that when he's dealing with individuals that have been stopped, rightfully or wrongly, that he's going to receive some sort of resistance in that. Considering those two elements of the statute in relation, I think that we could also argue that the words inconvenience and annoyance in the disorderly conduct statute really could be brought up in almost any stop that occurs with the police officer. When we remove these elements from the statute, basically what we're left with is the state having to prove that Mr. Taylor created some sort of alarm through the use of violent or turbulent behavior. There was no evidence presented that this interaction created alarm. Mr. Ross testified that he was not fazed by Mr. Taylor's reactions. The state was also trying to say that it could cause alarm to the daughter, who was also in the vicinity of this confrontation. The video shows that the daughter in no way was involved in this. She shows no reaction at all. And there was no evidence presented that in any way the daughter was impacted in this. And I think the argument the state was trying to make was that if Officer Ross was not impacted, didn't have any alarm in this instance, then it must have been the daughter that did. But there was
a body cam video on this?
There was a body cam video, yes.
The whole incident?
Yes. The trial court did, during the bench trial, make note that they were only considering the first 2 minutes of that video, that it took that amount of time to lead up to the arrest. So from the incident, from the time the body cam starts to the time that Mr. Taylor is arrested, there's approximately 1 minute and 48 seconds that have elapsed. During the bench trial, the court did state that they were only going to be considering, for the purposes of that trial, those first 2 minutes. On page 40 and 41 of the transcript, Officer Ross testifies that during the interaction with Officer Tucker, he responded that he was not arresting the defendant for violent and turbulent behavior. He basically stated he was yelling and being loud, but other than that, there was no other behavior or conduct that stood out to him. So ultimately, there was no other evidence that was presented to show that he was being violent, turbulent, or that he had created any kind of alarm in this instance. Moving then to the manifest weight, allows this court to sit as the 13th juror and weigh all of the credible evidence in this case. And basically this speaks to the burden of persuasion in this case. While most of the arguments for the sufficiency can be made, I think there are a couple of other points to make here. During the trial, one instance, one line of questioning basically spoke to Officer Ross's safety. He felt that the defendant had invaded his personal space. Again, as the body cam shows, Officer Ross actually positions himself in the way of the defendant without giving any indication that he wanted to stop or otherwise detain the defendant. I think this is very important because in Mr. Taylor's mind, he had retrieved his property, he was told to leave, and he was leaving. Also, in the manifest weight standard, it does speak of credibility of the evidence, credibility of the witnesses. And I believe here that Officer Ross's credibility really comes into question. On page 44 of the transcript, he is speaking about the report that he made on this case and makes a number of allegations that turn out to be completely untrue. He lists the defendant as chubby. He lists the suspect lists Mr. Taylor as a suspected drug user, also a suspected alcohol user, and that he might have a possible mental condition. None of these panned out. There was no indication on the record during the trial or during the report that any alcohol, drugs, or mental issues were raised.
Counsel, I'm going to stop the clock at this point. You have 4 minutes, 39 seconds left. You're free to continue, but you're ready to...
I'll continue.
Okay.
Thank you.
Thank you.
A number of other points I think need to be brought up as far as the manifest weight argument go. Officer Ross did initiate this confrontation, not by being professional, by initiating it by yelling directly at the defendant. He testified to this during the trial that he initiated it by yelling. He did not use an informative or a very professional approach when he first confronted Mr. Taylor.
Was he far away from Mr. Taylor?
He was, by my best estimate, maybe 30 feet, maybe double the distance between me and the bench. And it was not loud in that area. In fact, it was only Officer Ross, I believe 2 fire chiefs, as well as Mr. Taylor and his family that were there, so maybe 6 people total.
Is that on the body cam as well?
That is all on body cam, yes. Again, Officer Ross testified that he was not affected in any way by Mr. Taylor's conduct during this case. And again, the state tried to make an argument that it must have been the daughter that was impacted detrimentally by this interaction. Moving then to the constitutional argument, I know this was not originally challenged at the trial level. However, Criminal 52B does allow the court to address errors when they do affect substantial rights of the defendant. And in this case, I think we have a very large First Amendment argument. Appellant makes several notes of cases in this jurisdiction that really go to the language of those fighting words. Those cases have been distinguished in the brief, and I think that it's very important to show that the main case on point here is Norwell. In the case of Norwell, he was basically told to stop by police. And when he refused, the officer grabbed Mr. Norwell twice before arresting him. Both of those times, Mr. Norwell actually made contact with the officer. The trial court ultimately convicted Mr. Norwell for being noisy. Those are the words used by the court. He was fined $10 for being noisy. The court reversed on the record, basically stating, "We're convinced the petitioner was arrested and convicted merely because he verbally and negatively protested Officer Johnson's treatment of him." And I think that that really speaks to what this case is about. Mr. Taylor, at the time, which was testified to by Officer Ross, did not feel he had done anything wrong at that time. He was also confronted in a very unprofessional manner and frankly provoked when he was pushed against the rail. I think it was these things that really set the scene for what transpired after that. Here, Mr. Taylor had done nothing more than protest the stop that the officer had made of him, and frankly, I think that his words did not rise to the level of fighting words that would warrant a conviction in this case. I will reserve the rest of my time if that's appropriate.
1 minute and 16 seconds.
Thank you.
For a vote. Attorney Bremer?
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. I apologize, we were going to have a certified legal intern do this oral argument, but she had to go and get admitted to the bar. So she is in the audience this morning.
Congratulations.
A few points I want to raise initially, going to the second assignment of error that opposing counsel brought up at the very end. Opposing counsel has, from his oral argument, conceded that this was not a preserved constitutional issue raised below, and therefore it's waived on appeal. Furthermore, counsel is trying to avail himself of Criminal Rule 52B, which is the plain error. Plain error is not the argument that is raised in the brief. In this court's longstanding precedent is that if you don't argue plain error in the brief, this court will not consider it. With that in mind, I believe that the second assignment of error is not properly before the court as he is being articulated at this point. And a few other issues I want to touch on in this case. I don't know how close Officer Ross was. I'm terrible about estimating distance when the encounter begins. It is in the body-worn camera. We were actually speaking for this hearing that you can see the whole thing, where you can actually see Mr. Taylor lean over the railing in the body-worn camera, and then so you can see where the pick came out of his hair, and then you can see him go underneath the tape, and so you can actually see the entirety of the encounter. I think it's further than 30 feet. I think it's actually a fairly significant distance.
Was there any testimony?
I don't know if there was any testimony. When you watch the video, though, Officer Ross has to cross the sidewalk, go up a hill, and actually then approach Mr. Taylor. And I think it's probably closer to about 100 feet away when during this encounter. Which again, that's not really at issue in this case so much as he is yelling across that distance. Also, unfortunately, the video does not have audio for the first about 40 seconds or so. It is so you don't actually get to hear what Officer Ross says when Mr. Taylor initially goes underneath the tape cordoning off the area, and when he approaches. Mr. Taylor Officer Ross testifies, though, that Mr. Taylor was belligerent immediately towards him when he called out to him. And Mr. Taylor ignored his directive to leave the restricted area and proceeded further into the restricted area.
Did he tell him why he was going in there?
I believe that Officer Ross did not immediately know why he was going into there. The testimony is at best unclear about whether Mr. Taylor immediately said, "I'm retrieving property." The fact is, Officer Ross saw someone going to a restricted area, called out to him, told him to stop, and Mr. Taylor disregarded that. And after speaking with Mr. Taylor at the end of this encounter, Officer Ross at that point was aware that he went in to actually get the personal property. But when the encounter began, he did not know that. And Mr. Taylor was very aggressive and belligerent to him during the encounter, basically trying to antagonize the officer and being very upset at being questioned by the officer.
At that point, was there a crime committed?
There was this area was cordoned off. It was a area that Mr. Taylor was not allowed to be in, and to the extent that he walked into an area that he's not permitted to be, it's a trespass.
But he wasn't convicted of trespass.
Well, just because someone is not convicted of a specific crime does not mean that the officer doesn't have reasonable suspicion to stop.
And I'm not going down that road. I understand what you're arguing. But
Yeah.
as far as this case, he hadn't committed the offense of disorderly conduct at this point.
When Officer Ross went up and spoke, initiated the contact, you mean?
Right.
Correct. It's the totality of his interaction with Officer Ross. It goes to the fact he disregarded Officer Ross's directive to leave the area he was not permitted to be, and then when Officer Ross spoke with him, he was continually belligerent. He used profanity towards Officer Ross.
That's what I'm getting at. Do you think, is it your argument that the use of profanity and those words that he used created the annoyance and element of the offense?
Yes.
Or is it the brushing up against him, or?
Well, and I guess that this actually touches on another issue that from the description of the events. Mr. Taylor was never shoved against a railing in this case. Officer Ross did approach him. Mr. Taylor then approached Officer Ross and entered into what Officer Ross described as his personal space. Officer Ross testified that he believed Mr. Taylor was going to brush past him, and that created a concern in Officer Ross that Mr. Taylor was basically that was going to escalate the situation because it would be basically leaving the questioning that Officer Ross was trying to engage in, and that Officer Ross.
When you say he was worried that he was going to brush past him, was he heading back out to the non-restricted area, or was he attempting to brush past him and go further into the restricted area?
I don't want to fully speculate about where Mr. Taylor was going, but he was walking back towards the tape. He would have been able to probably leave the area if he continued in the direction he was going. Having said that, though, once Officer Ross is speaking to him, Mr. Taylor needed to actually engage with Officer Ross under these circumstances. And Mr. Taylor trying to brush past Officer Ross actually actually escalated the situation.
But you're in a restricted area that's roped off for fireworks. Wouldn't it be consistent with what that rope's there for, to have that conversation 3 or 4 feet to the side in the non-restricted area? Would you want him out of that area?
While there may have been a better place to have the conversation than what Officer Ross chose, Mr. Taylor doesn't get to dictate where the conversation happens. And by trying to do so, again, he was very belligerent during the encounter. When you watch the video, when you read the words on the page, it comes off very clinical. When you watch it under the circumstances, it becomes more clear why Officer Ross arrested him for disorderly conduct. It was just, when you look at everything that happened, him going into a restricted area, ignoring the directive to leave the restricted area, basically Mr. Taylor decided that he gets to decide when he leaves the restricted area. And if he had left immediately and then said, I need to retrieve my phone, Officer Ross may have said, oh, I understand, go in. But he chose to disregard the directive to leave and then went in further to get the property. Whether or not he could have retrieved the property ultimately is not the precise issue. It is actually about whether or not you can choose to disregard the police officer's directive and then swear at the officer for trying to actually have a conversation about what are you doing here. And Officer Ross tried to get Mr. Taylor to identify himself, and Mr. Taylor refused and used profanity towards Officer Ross during the refusal. And again, it's the totality of everything that happened here. Officer Ross was taken away from actually trying to patrol the area to engage in this conversation with Mr. Taylor. The encounter went on far longer than it needed to because Mr. Taylor was just offended by the fact that he was being questioned for being someplace he wasn't allowed to be. And that's really ultimately what happened in this case.
Is that inconsistent with the statement to the other officer that this was not a violent, turbulent situation?
I would say that Officer Ross, when he answered the question to the officer, was still processing everything that he had experienced with Mr. Taylor. And just because Officer Ross says he's not a BT at the time, it may have been when he actually sat down, thought through it, he reevaluated his actual analysis of, yes, this actually does qualify as the BT under violent and turbulent behavior for this offense. And the issue is really just that Officer Ross doesn't have to know exactly how he's going to charge someone in that moment. He does have an opportunity to reflect upon everything that has happened. And obviously when Officer Ross reflected, he determined that the behavior fell within the disorderly conduct ordinance. The other issue that is being argued extensively by appellant in this case is the idea that officers have a different standard. That this court has rejected that argument previously in Bozic, I believe, B-O-Z-I-C. It is a reasonable person standard for whether the behavior constitutes fighting words. It is not a reasonable officer standard. Now, again, as we argue in our brief, the issue here isn't the actual content of Mr. Taylor's speech, it's his behavior, if that's what he was charged with. There's a different section of the ordinance that goes to the actual content of the words. That was not what he was charged with. Every case that is cited by appellant deals with the content of the speech portion of the disorderly conduct statute or the disorderly conduct ordinances. And so the arguments that they're raising regarding constitutionality, even if they aren't waived, are actually to a different portion of the statute than what he was actually charged with here. He was not arrested for the content of his speech, he was arrested for the behavior, and that includes the tone and the manner in which he actually delivered his speech. Finally, finally, I would say that the reason we raised the issue of manifest weight not being properly preserved in this case is that when you review the argumentation advanced by appellant, there is not an actual separate argument for manifest weight. It's all couched in terms of sufficiency. Sufficiency and manifest weight are inherently different standards, and they require different argumentation to properly articulate them. That did not happen in this case, in the brief. There are some arguments about credibility, which would go to manifest weight, but again, they get wrapped up in the sufficiency argument, not in a separate argument about whether or not the trial court clearly lost its way when it found Mr. Taylor guilty of disorderly conduct. That's why we were making the argument that it wasn't properly preserved here, and that's why we believe it's closer to those cases we cite in the brief than being distinguishable. If the court doesn't have any further questions, I will respectfully request that you overrule the assignments of error and affirm the decision of the Akron Municipal Court.
Okay, thank you for the argument. Counsel, you will have 1 minute and 16 seconds for rebuttal.
I would just like to clear up a couple of factual disputes that came up here. When the initial confrontation happened, regardless of the distance, I would say that it is very significant that at the time of this, Officer Ross was sitting in a chair, basically mucking up with the chiefs that were there at a great distance, probably not really paying attention to what had happened in this incident. He did testify that he yelled at the appellant initially, and the appellant, when yelled at, did inform the officer prior to their physical distance closing what he was there to do. So Officer Ross was aware of why the appellant had entered into that space. Aside from that, I think that factually the body cam shows a lot of what this case is about, and I believe that would be my time. Thank you.
All right, thank you both very much for the arguments on this case. The court will take the matter under advisement, issue a decision in the court. The clerk will mail you a copy of the decision on the day it is released, and you may also find the opinions on the Supreme Court of Ohio's website. Always a pleasure to have argument from both sides, so thank you for being here